Rural land activists who form part of the Stop the Bantustan Bills campaign are urging President Cyril Ramapahosa not to sign the current version of the Traditional Courts Bill into law. Parliament passed the bill earlier this month. Joining me now is Nolundi Luwaya, Director of Land and Accountability Research Centre at UCT. Nolundi, good morning. It's been 14 years since the amendments for this bill started. Which of these amendments is the organisation not particularly satisfied with?
Good morning, Hugo. Thanks for having me. The organisation is concerned with the bill as a whole, actually. The entire bill itself, which has taken 14 years to be drafted, is, in our view, highly problematic. There has been an extensive parliamentary process to try and involve rural voices during the drafting of this particular Traditional Courts Bill. But our concern is that the voices and concerns of those rural communities have not actually made it into the content of the bill as it stands at the moment. So the idea of the Traditional Courts Bill is that it would regulate traditional courts, which are, of course, an important and useful forum because they provide local access to justice for rural communities. However, there are concerns about what the bill makes possible and whether or not the protections that it puts in place for vulnerable groups like women, whether those protections are actually adequate. So really our concerns run throughout the bill. And what we're really calling for and objecting to is the fact that rural voices have not necessarily been taken seriously and their concerns are not reflected in the current version of the bill, which makes its way to the President.
So whose concerns are reflected if not that of the rural folk?
In our view, Hugo, the bill really leans towards favouring the concerns that were raised by traditional leaders and lobbies and groups that are in support of traditional leaders. And so part of what the bill does in its current form is it really feeds into this narrative that emerged in the Parliamentary Portfolio Committee around wanting to make sure that these traditional courts are, afforded proper dignity and that they are taken seriously. And so, for example, one of the main issues that is not reflected in the bill that was called for by rural communities and civil society is something called an opt-out clause. What an opt-out clause would allow is it offers the choice to people whether or not they wish for their matter to be taken to a traditional court. Now, the Parliamentary Portfolio Committee and certain members of traditional leadership groups objected to the opt-out clause because in their view it undermines the authority of a traditional court if you offer people the choice. We are asserting that it doesn't undermine the authority of a traditional court at all, but actually legitimizes that court even more because people are then choosing to use that court because for them it isn't a legitimate avenue of accessing justice. Those types of concerns have not made it into the bill.
Now let's talk about transparency or the lack thereof. Are you happy with that the process was transparent in coming up with the information that was required in putting across this bill?
So the parliamentary process has been a long one. As you said, it's been 14 years, and certainly the opportunities were there, although sometimes slightly inadequate for communities who would be affected by this bill to offer their views, their concerns. Those of us who do research in this area also had opportunities to put forward submissions. There was extensive opportunities for engagement. The concern is that it seems there was no robust consideration of that engagement, and we see that reflected in how the bill is currently structured. There is absolutely no uptake of some of the suggestions that were put forward, like the opt-out clause, as I mentioned, but also other concerns around how else women could possibly be protected in these traditional court forums. So the concern is about whether or not the Parliamentary Portfolio Committee took seriously the information and the views that were put before it. And we seem to feel that it did not, because the bill doesn't reflect any of that.
Now, Lundi, let's talk about numbers. Is this not a numbers game? And the reason I ask this question is if two people, for argument's sake, who represent a certain segment or certain sector of people in the rural areas are pro point A and 6 say we are against point A, surely it's the 6 that will be considered. Is this not a case of what could have transpired?
Yeah, Hugo, look, it's absolutely a numbers game. Ultimately, this bill is an ANC-supported bill. And so the reason why it was passed and why it now makes its way to the President is because of the majority held by the ruling party at this point. Objections to the bill came from all of the opposition parties, which of course is not a surprising theme for us. So it seems that, the numbers effectively are stacked in a way where regardless of what rural communities who make up the majority ultimately of the people who will be be affected by this bill, regardless of what they say, and even if they might have the numbers, those numbers cannot hold up against the fact that the ruling party has the majority, and if this is a bill that they support, it will pass regardless of the views of those who will be most directly affected.
Now, the rural voices that you speak of are obviously governed by traditional leaders. Talk to us about that relationship between the traditional leaders and the rural folk. Surely there is a disconnect if the traditional leaders are not representing the very people that they are seeking to represent, if you will.
Sure, absolutely. I mean, people who objected to the content of the bill made it clear that this is not about being anti-traditional leader. Rather, this is about a version of customary law that better reflects the ways in which people actually live their lives. It's about acknowledging that customary law is a voluntary-based system. It's a system that's based on voluntary affiliation. And so for some of these community members, they absolutely are happy to work alongside their traditional leaders. They are just concerned about the state taking an approach that forces and imposes these kinds of choices on people without offering them any real or valuable engagement. Of course, traditional leaders, make up an important component of customary legal systems, and this is not to say that they don't have a role to play, but it is about flagging and raising questions about what type of traditional leaders feel that they need to force people to attend their courts. What is the message that's being sent when one is actually beginning to limit the choices of rural citizens who, of course, are also part of South Africa and hold the same rights that urban South Africans do? What happens when you're seeking to limit their choices in order to bolster the power and the authority of particular sections of the traditional leadership grouping?
Now let's bring Parliament into the conversation. Is Parliament aware of these objections?
Yes. So many of these cases were tabled at the various public participation processes that happened in Parliament over the last 14 years. We've worked with partner organizations to bring rural women who have direct stories about how they were treated and mistreated in traditional courts, who have made statements and submissions to Parliament, who spoke at public hearings in front of parliamentarians. All of this information was made readily available, which is why it's such a bitter disappointment that after such a long process, none of those concerns have been reflected in the version of the bill that's going to the President.
Now, has there been any effort to engage the Presidency regarding this bill? Obviously, now it's at the sign-off stage, and any delay, I'd assume, would see that bill being signed into law before those issues are taken into account.
Yeah, absolutely. So being in touch with the Presidency is the next step for us. It's to request the President not sign the bill into law, but rather that he refer it back either to Parliament or to the Constitutional Court, because we have concerns about whether or not the bill itself is constitutional without this opt-out clause that I was referring to. So our concern is whether, it is constitutional to deprive people of a choice as to whether or not they wish to make use of traditional courts. So certainly reaching out to the President, asking him to not sign the bill, but rather to consider taking up the options available to him to have the bill reviewed in terms of constitutionality is the next step for the campaign. If that fails, it would seem that perhaps we might have to consider taking the bill on review and take it to the Constitutional Court. But it would be really powerful to have the President, at very least, hear the concerns put forward by rural communities and not sign the bill into law.
Nolundi, final question, and this obviously speaks to women. Allow me a little bit to read from here. One of the public hearings on the bill, a regional magistrate informed the Committee on Justice and Correctional Services that he and his colleagues had held 5 workshops with traditional leaders and found that women were participating in traditional courts. But of the 256 participants, only 23 were women. So, 2 parts to the question. Is this bill inclusive of the needs and demands of women, firstly? And secondly, could there not have been a greater participation by women to push for their various causes?
So on the face of it, the bill is inclusive of women and does seem to, at face value, acknowledge their needs. So, for example, it stipulates that women need to compromise 50% of the traditional court.
Take it easy, man.
The difficulty, Hugo, I think is, the bill does not necessarily take a very kind of deep and nuanced approach to traditional courts and the challenges that women face. So even though they are required to be 50% of the composition, what isn't addressed are issues like the fact that women who are in mourning are not allowed to address many of these forums themselves. They have to have somebody speak on their behalf. That, for example, is not, addressed in the bill at present. Could there have been more participation, more consideration of women's concerns? Absolutely. As I say, women are a particularly vulnerable group in some of these contexts. And so taking more care, more consideration to ensure that their issues and concerns are brought forward could have been built into the parliamentary process. Although those who, from civil society and also rural activists did work very hard to make sure that women were afforded opportunities to participate. So it's really a disappointment and sends a sad message to rural women that the bill doesn't have more robust engagement with the particular protections that women need in those particular contexts.
Nolundi, appreciate your time this morning. Nolundi Luwaya, Director of Land and Accountability Research Centre at UCT, unpacking for us what they call unconstitutional passing of the traditional courts.